Well, welcome to National Herald. Naujivan and Qaumi Awaz. Thanks for agreeing to come here at such short notice to discuss the crisis in the judiciary. So my first question, would be that you have been a law minister yourself, and you have been observing, the Supreme Court for such a long time. How do you expect, this crisis to end? As a dam squeak, or do you expect, some changes to take place?
Very, very difficult to predict. Very difficult to predict. You started with my having been law minister, and I tell you how difficult the job of a law minister is. I have various models of law ministers before me, and I'm sure that you know about them. A law minister's job is not to be completely aloof and disconnected with the higher judiciary. If that's the case, then you're a clerk, then you're not a law minister. Then you just take an account of how much money they need to build new rooms and pay for their staff and buy new cars, and sometimes you say yes and sometimes you say no. But that's not what a law minister's job is. Law minister's job is, in a sense, to be a facilitator for the judiciary, in a sense to provide a connect between the judiciary and the executive and parliament, and perhaps to some extent about public opinion, to be not strictly speaking a conscience keeper, but someone who can nudge the conscience a bit, and also convey in general terms concerns about an elected government on issues that are far-reaching. Now, if there is, for instance, a concern about something like the Aadhaar card, so you don't go and tell the judge, please decide it in this way or that way. That amounts to interference. But there are things that you are unable to say in court, and you can informally meet with judges and give your idea of what the Aadhaar card is all about and why it's so important for the country, etc. Now, the lawyers will put it in their legalistic language, but the law minister can certainly do this without saying, so have you understood? Will you say yes? You don't go to that point. If you are sensible and you're polite, you just say, this is our concern, we hope that you will keep this in mind, and so on. And judges in return would say that, look, we are very, very grateful that you've shared this with us. And of course there will be an affidavit and we will look at it. But we'll make sure that the government has a comfort level as far as we are concerned. We are not here to carp and be critical of the government unnecessarily, as long as you are functioning within the law. Now, this is a legitimate conversation.
And this is something that has been happening,
it happens. It's a convention.
It's a convention. It happens. It happens all the time. I can say that I did it with many judges, and I was particularly careful that you never cross the line.
Would you say that the communication has broken down between the law minister and the judges?
No communication. If this is what's going on, and the law minister has to say that I have nothing to do with this and let them solve this themselves, etc., then obviously there is a lack of communication. Communication means judges are expected not to socialize too much, and both sides have to be careful about this. So you can't be meeting in pubs and parties and restaurants, etc. But you have to call on the judges. You have to go spend some time, call on them. They are decent enough to give you a good cup of coffee, as indeed you're giving me. And I've known judges to provide you with sandwiches, etc. But that doesn't mean that I've given you a sandwich so you can have the decision your way. That's not what we expect, and that's not what they give. But to say that we have nothing to do with this is wrong. There has to be some level of enlightened communication, and normally it can be done by the law minister himself. Sometimes, as I did, I would use the Attorney General, because an Attorney General is the officer of the court, and he's supposed to be able to, with a little more ease, convey your messages to the court. But again, not take any commitments from the judges that we will do this or we will not do this. Sometimes you need a case expedited, right? And then you would say this is highly urgent. These are tax reform issues. We need this decision quickly. Whether you decide in our favor or against, but we need a decision quickly. You can go and say this in court when you do mentioning, but you can also, Attorney General or someone can call on the Chief Justice and say, please, can you do this for us? So a communication level has to be there. It'll be absurd for anyone to say that, look, this is their problem, this is not our problem, we have to.
Salman bhai, I'm sorry to interrupt and bring you back to the issue. It's being said, and you know, and everybody is being observing the fact that what happened in the Supreme Court yesterday is unprecedented. What in your view triggered the crisis? What is the crisis?
To truthfully tell you, I don't know. I don't know what the crisis is, because for judges to have left in the middle of the day, of a working day, and held a press conference, they must have felt a very severe urgency. They could have done it at 4:15, which is what judges often do. If you say, can you come to a seminar or a book release, they'll say, I'll come at 4:15. Finish the court at 4 o'clock and come at 4:15. Day before this happened, there was the most outstanding lecture in ILI. It was at 4:15. And that outstanding lecture was of one of the top judges, retired judges of Australian High Court, Justice Michael Kirby, who was speaking on comparative constitutional experiences of Australia and India. And the lecture was presided by Justice Chandrachud, and he again made presidential remarks, and they were both were brilliant. I have never heard anything better at the Indian Law Institute than I did that day. And they were talking about the role of judge. In fact, Justice Chandrachud spoke a great deal about what he called, and if you can get a copy of that, my God, I think it should be published. He called the constitutional silences. He said a constitutional silence that a judge has to fill to give a citizen something that the citizen does not get because of that silence, and a constitutional silence that denies the state something, but it doesn't actually say so in the Constitution, but the constitutional silence about that is to be filled by a judge. And how does the judge do this? How does the judge fulfill and fill the gaps of constitutional silences? A brilliant lecture, a really
Yesterday
brilliant
it seems that the 4 judges broke that constitutional silence or conventional silence, whatever.
So that silence broke down. I mean, or that they expressed their agony and inability to fulfill the responsibility of filling that gap, because circumstances were not permitting them to do so. So they broke their silence in another sense, because they could not fill the gap of silence, is how I would put it.
Was it required?
But was the urgency so great that
Yes.
it had to be done at 12?
Yes.
Why could it not at the press conference? It didn't seem that there was such urgency. There were issues. I mean, clearly there were issues that were important, but issues that could have waited till 4:15.
Are the issues serious enough to
The issues are very serious. Issues are very serious if you consider how far-reaching decisions of the court can be. I mean, for everyone, and any issue is issues of life and death. These are issues about life and death of a nation. These issues that the court
that's
has
serious.
decided. Absolutely. So they have to be decided by the court, and they have to be decided by the court one way or the other. The court has itself over the years indicated that it is uncertain about the finality of its decision. The court itself. I'm not saying so. The court itself. Because the court has a manner in which it hears a case, then if somebody feels the case has not been rightly decided, you can file a review. A review is heard by the same judges who have decided the case. You can ask for a rehearing. Sometimes it's allowed, sometimes it's not allowed, sometimes the review is only by circulation. But even after a review is dismissed, there is something called curative, which is unheard of anywhere in the world. And the curative is that the judges who are still remaining on the bench, who decided your case, along with the 3 senior-most judges of the Supreme Court, 5 of them have to consider whether what you are saying is right, that there is, despite everything, there is something that has gone wrong, that is caused injustice. And on the curative petition, which is to be certified by a senior lawyer saying this merits a curative petition, the court has to consider. So isn't it very clear that the court does not seem comfortable about the finality of its decision making? So it creates these instruments by itself. Even after a curative is dismissed, you know that periodically a new generation of judges, and when I say a new generation of judges, it only means 5 years. It does not mean 30 years. 5 years, there's a new court. This year, 8 judges will retire. There are 28 judges.
And
8 will retire. 8 will retire this year.
A new generation would come in.
So a new generation will come in. And in the time that the American Chief Justice will be Chief Justice of the United States United States Supreme Court, India will see 20 Chief Justices, at least. 20 Chief Justices. So the generational change is much faster here. Now, and you know that in the generation changes, there are so many matters in which a later generation judge says that the decision of the earlier generation judge was wrong. And they change it. Chandrachud today is the first Supreme Court judge who has overruled his father.
He overruled his father.
His father's judgment in the Shukla case, in the emergency matter.
Right.
Chandrachud actually has overruled it. If you read his recent judgment, you find that he's overruled that case. So
we were talking about the issues that they have nailed down, and one of the issues is the lawyer, Justice Lawyer's issue.
No, it's not an issue. It's
is
a
it
very
such
simple,
a serious thing that
it's a serious thing, and it's not a serious thing.
Serious in what sense?
It's an issue about investigating the death of a judge.
Yeah.
Right? Now, it can be pretty commonplace that a judge has died, and because he was doing an important job, therefore, whoever is told that such and such thing has happened should immediately say, look, let there be a... The issue is important is that when something like this comes, and it's relatable to and related to independence of the judiciary. Now, pressurizing judges is one thing. Shifting them around is another. Getting away from a tough judge and going towards a compliant judge is yet another. But the death of a judge, if it's...
But that's what the judges seem to be complaining.
So that's what they're saying. Such a serious matter...
They were not allotted...
No, they're only saying that such a serious matter, you should send it to the senior judges. I mean...
That is the convention.
It's common sense. It's convention. Now, what I'm saying is that there is nothing that one can really do about this is because, now I make a startling statement, India does not have a Supreme Court.
What do you mean?
Look at the US, look at UK, look at Canada, look at Malaysia, look at Singapore. Look at what their Supreme Courts are. Their Supreme Courts are 9 judges sitting in one room hearing
all together.
Here 28 never sit together.
Here at max 11 or 13.
2 sit, 3 sit, 5 sit, 7 sit, 11 sit. And
but not the entire court.
Not the entire court.
Bench.
Not the entire bench. So even constitutional matters are essentially heard by 5 judges. Now, when 5 judges hear a constitutional matter, come to one conclusion, there may be 23 other judges who think differently. And you never know whether they think differently. Death sentence. 5 judges decide death sentence is valid. Minority institutions, 5 judges decide minority institutions are valid. Something else, privacy happens, 7 judges decide. Now, 7 judges have given you a judgment, an outstanding judgment on privacy, but we want to know what the other 21 think. We don't know. We will never know. Now, if perchance, out of those 21, 10 happen to sit in some case, and they'll say this privacy thing is bunkum. In which case the privacy thing will go. Now, what is the solution to this? I don't know. There have been people have talked about solutions, which is that there should be a court of appeal and there should be a Supreme Court of a constitutional nature. So all constitutional matters must go to the Supreme Court. The Supreme Court should be one court, or at best there should be 2 courts, 5 and 5 or 7 and 7, but not 2 and 3 and 2 and 3, etc., which is not. So if you don't have a Supreme Court, and there's a choice of 15 courts to which you can go, then you try to go to the one that you like, somebody else likes to send you to the one that they like, etc. This has been this has been a problem for a long time. But it was resolved largely when the computers came in, that you just said, make categories, make benches, and send according to categories, send to the bench. Nobody can tell the chief that Judge A and Judge B should not sit together unless Judge A and B can't talk to each other. Right? So nobody tells him, and he puts A and B together, C and D together, E and F together.
So is it the computer which decides the combination?
No, the combination is decided by the chief.
Okay.
But
the cases
then he says first combination will do commercial matters, second combination will do criminal matters. Then the computer sends to the concerned bench.
So cases are then allotted.
Cases are
by the
allotted.
computer.
So you can't hand pick.
Mm-hmm.
You can't hand pick.
Mm-hmm.
Right.
But it seems that Chief Justice of India was, if I may say so, was handpicking the judges.
No, now.
That seems to be
Now,
the
no. But this every Chief Justice does. When 5 judges meet in the Supreme Court for the constitutional bench, they're not always the first 5. They're somebody here, somebody here. Triple Talaq. Now, understandable, in Triple Talaq, they had one Muslim judge, so they brought him, which is Nazir Saab. They brought him in Triple Talaq, the five judges. One was Nazir Saab, so he came in. It's understandable that if you're deciding something about Parsis, that you take the Parsi judge. When you're deciding something about Muslims, you take the Muslim judge. But the Triple Talaq was a very interesting bench. The Triple Talaq had a Sikh, had a Muslim, had a Parsi, had a Christian and a Hindu. Now, you think this happened by itself? You think it happened by itself? This was done by the Chief Justice. But because this seemed sensible and fair, nobody complained. Right? Nobody complained. But if this did not seem sensible and fair to someone, he would have complained.
Are you suggesting that there was this allotment business for which four judges seems to be angry? It was just
overreaction.
Nothing wrong about it?
No. I'm not saying that. I'm saying that it's difficult to correct this because your system allows you to do it. Mm-hmm. Okay, now, but
was there any design? That is the message that seems to have
what these judges are saying is that why are all these important matters going only to a particular bench? Why? This is what they are saying.
Right.
What we have said in the party is that matters which are of such high importance to the country and far-reaching consequences should be heard by the senior-most judges. This is what we have said. Please remember what Kejriwal used to say when he used to talk about some benches. That he used to say that for deciding who the head of the Lokpal will be, you'll have 3 senior-most and 2 junior-most judges. See, he used to also try to balance that. So you can work on any combinations. But the benches are made by the Supreme Court Chief Justice, and there is nobody who said that there is any other way of doing this except by a way of convention, saying that where there are important matters, they should go to senior judges. But listen, there is one judge who is very good in company law, he is very junior. You are deciding a matter which is a very important thing for commerce in our country, which is to be decided by 5 judges. And you say because this guy is junior, we won't keep him. Doesn't make sense. Well, my problem is that you can't really fix an institution unless there is somebody who heads that institution for a reasonable number of years. I felt that the Chief Justice of India should never be less than 3 to 5 years. I was told by a Chief Justice, for God's sake, don't think of this. You get a bad man, you've had it. A Chief Justice, sitting Chief Justice told me that. If you get a bad man, you've had it. It's best to leave it a year and a half, 2 years, no more. But I personally think that Chief Justice has to be around for a while. The last Chief Justice who was around for a while was Chandrachud. After Chandrachud, it was, I think, Balakrishnan, who was for about 3 years or 3.5 years.
How would it, you're talking about the structural problem. I'm talking of the people's perception, which is very important in a democracy. There is a doubt about Supreme Court now, and there is a doubt about the government that it interferes, which is very serious. So how?
Well,
you have been a lawman.
No, I know. I know that there are issues that lead to the government in this. There are issues that lead to the government, and but as a responsibility I owe to the court, I have to ensure that I don't oversimplify it to give an impression that there's a court that does no conscience and no courage. I will do a greater disservice to the court than the government might ever do if I say such a thing about this court. We have to say that our faith in this court will remain. We have to say that we have to stand by this court. We have to say that the court itself must heal its own problems, and we will help it do so in any way possible.
You don't see any role for the government in this stage, or?
Well, I see a role for sensible people who have access to the court. Now, if
the law minister is not sensible enough?
I'm just saying that I don't want to rule out anybody, but I'm just saying that you have to be sensible.
Let me put it differently, do you think, a status quo, will help the judiciary, or do you?
No, status quo obviously will not help because it's looking bad. Now, I'm not sure that my mind is clear about how judges are to be appointed. See, this MOP is about appointment of judges, right? So there is a disagreement somewhere about appointment of judges, which is why we are not being able to appoint judges. Now, it's worked and it's failed as well. Both things have happened. In a situation where there are no easy answers, if somebody plays a myopic role of trying to create stresses and pressures over the court, then I think that'll be the greatest disservice they will do. I feel for myself, and I feel for all those of us who are in practice or in any way have admired the court, etc. I feel protective of the court. I feel that we have to do something to protect it from greater erosion of confidence. Sometimes telling the truth is important, but truth is important when truth comes for purposes of reconciliation. So if you follow the pattern of Nelson Mandela, truth and reconciliation, then you get something worthwhile. But truth just for truth's sake will not get you anywhere. So if there is
reconciliation, you see?
there has to be some sensible people pushing it towards reconciliation. We see reconciliations happen in the judiciary and between the judiciary and the bar every day. Things go bad, things get bitter, and then you make up for it. I think that there's a high responsibility of all the judges of the Supreme Court to both establish the truth and move towards reconciliation. And I think it's the duty of every Indian citizen to do whatever they can, including by keeping their mouth shut, to allow the reconciliation to move forward. I don't think it helps anyone to break up this court or create more cracks in this court or split the court into several groups.
I have two questions. I'm sorry.
Sorry.
No, I have two questions. One is that what do you think are the options before the Chief Justice at this point?
The options before the Chief Justice are, frankly, to have a frank chat with these four and anybody else who feels discomfort. I mean, just because four have come here, I talk only to those would not be right. And if he feels that there is that they have jumped the gun, as it were, then he can put his point of view across to them. They will still regard him as Chief Justice. They've referred to him as Honorable Chief Justice. They've not just said Justice Mishra. They've said Honorable Chief Justice. So they'll still regard him as Chief Justice. All of them have been Chief Justices in their life. One will be the Chief Justice of India if all goes well in 8 months' time. So I think he needs to have a chat with them. I think that they need to have an open mind to talk to him. I think the whole court together has to create an atmosphere in which reconciliation is possible. Today, while it's of the highest priority that these cases that have got flagged in this letter are handled properly, appropriately, including Judge Loya's case, which our party has taken a very, very strong and strident position on. While they must be handled properly, I think it's also important that we don't lose sight of the need for reconciliation in the court.
सर आज वीरेंद्र मिश्रा गए थे वहाँ पे, उनसे पूछा गया कि आप चीफ जस्टिस के घर गए, उन्होंने घर में ग्रीटिंग देने गया था नए साल की.
Naya Sal greeting, little bit late in the day, no? Unless they went for Lodi and so on, but a little bit late in the day.
कि जब किसी भी देश में कोई फंडामेंटलिस्ट रूल करना शुरू करते हैं, लाइक पाकिस्तान से लोग कह रहे हैं कि जिया के टाइम में वहाँ पे जुडिशरी के अंदर बहुत फंडामेंटलिज्म बढ़ा था. तो आप ये बताइए कि आप ऐसा कुछ देखते हैं हमारे यहाँ भी जुडिशरी की सिस्टम है उसके अंदर एक फंडामेंटलिज्म बढ़ा है मोदी गवर्नमेंट आने के बाद?
देखिए, एक जजेस का एक रेंज होता है हर व्यवस्था में, हर सिस्टम में. अंग्रेज़ी में उसको कहते हैं इज़ ये हैंगिंग जज. मेरे एक ट्यूटर थे, यंग ट्यूटर, वो बाहर से आते थे पढ़ाने के लिए. सो वो एक किसी जज के बारे में बात कर रहे थे कॉन्वर्सेशन में. तो ही सेड दैट दिस क्रेजी गाय, एंड वी ऑल सेड what makes you say so that he's crazy? He said, well, you just walked up to him at the railway station and said, good afternoon, Judge, how was the day today? And he said, not too bad, hang 3. So now, right, I mean, yes, he's a good English judge, but hang 3. So I mean, there are judges like that, hanging judges, and there are judges that say that we must reform, we must give a human being a chance, and so they go into that rarest of rare cases thing that create a situation in which I mean, rarest of rare in English language, there is no such thing as rarest of rare, there's only rare. So what is rarest of rare? And they still manage to hang people after rarest of rare. They still manage to find that. But as I'm saying, there are judges who are reluctant to hang and find any excuse not to hang. And there are judges who are willing to hang and happy to hang and saying that it wasn't a bad day if I've hanged 3. So this range of judges you will have in any case.
Okay.
In any case.
So you
And
don't see any trend in
okay, so then if you have this range of ideology about judicial decision making, there is also a range of ideology of social thinking, political thinking, etc., etc. Which is why there is a demand that there should be judges from the backward communities, more Dalit judges, etc., because their response and reaction will be different. Their reaction and response will be different. Then obviously judges are human beings, and they would have political ideology as well, and political ideology may or may not influence what they do. Now you can be extremely right-wing, but in deciding in criminality you may be liberal. You may be liberal, but if you start permitting your political ideology to come in the way of your decision making. Now the problem with the Constitutional Court is that a Constitutional Court is dealing all the time with at least the hovering political ideology. So clearly if a judge is a Marxist, you will expect one kind of decision. If a judge is orthodox, conservative, religious person, you will expect another kind of decision. So what do you do? The statesman and the Chief Justice balances it in the manner in which Chief Justice Kehar balanced the Triple Talaq bench, right? That there is a Parsi, there's a Muslim, there's a Christian, there's a Sikh, and there's a Hindu, right? So that's the model. The law doesn't say this. Supreme Court rules don't provide it. Even the conventions don't provide it. Gently, obviously somebody should be there. Shabano was decided by a bench in which there was no Muslim judge, right? So Muslims can complain that you don't understand what the Quran requires. You didn't even have one man who understood, who was there, who would say what the Quran requires. And here was, although he didn't speak, but he agreed with Justice Kehar. Justice Nazir, he agreed with Justice Keir. But on the other hand, it was Justice Joseph who said that triple talaq has no place in the Quran. And he read the Quran. So here was a Muslim who didn't agree with him, meaning he agreed with someone else, who said that triple talaq has been there for 1400 years. So there are two different views that judges have taken on something which seems quite simple. I mean, it's either been there or it hasn't been there, right? So, I mean, you can check 1400 years how many people have given triple talaq, and on data come to a conclusion it's not there. But nobody actually bothered. Somebody said it's been there for 1400 years. They said, fine, good, it's been there. So it's part of Islam. Another guy said, I read the Quran, it's not there, so it couldn't have been there. If somebody did it, was wrong, therefore there's no triple talaq. The third said, no, I know triple talaq has been there, now it's become part of the constitution, but it's illegal, it's unconstitutional. That's what Nariman said. But the simple propositions of these 5 judges was not understood by this government. After the Supreme Court said there is no triple talaq, or if there is, it is held void. Finished, there is no triple talaq. What does Parliament say? Triple talaq is an instantaneous form of talaq. We outlaw it. How can they do it? It's not there already. And having outlawed it, we will now punish people for saying triple talaq. Now, when somebody says triple talaq after the Supreme Court judgment, he's doing something that is impossible. Right? He's doing something that's impossible. So this is the first time in the history of common law that somebody is being punished for doing something that's impossible.
So, just political question. Your party has said, took a very strong view of it, said that these are the very serious issues that the 4 judges have raised, and they should be, and especially on lawyer, they said there must be some inquiry. So what does that mean, and what kind of inquiry can be done?
No, they've said
when a case is already under.
No, they've said that there should be whatever is done should be done under the scrutiny and monitoring of a senior Supreme Court judge. That's what our party has said. But to get to that point, they will first have to be a Supreme Court bench that repeats the same thing, right? And then the Chief Justice gives one judge to inquire into the matter. And the issue arose because the bench that is to decide this turned out to be a bench that was, by these judges' logic, a hand-picked bench.
Since we are discussing this particular case, what exactly is the merit of the argument that since there is a petition in the Bombay High Court, the Supreme Court should not have heard it?
It's neither here nor there. Supreme Court hears all the time petitions that are filed in the High Courts. Supreme Court often says, I'm withdrawing that petition here, we'll hear it here, or says, no, we'll hear it also, there's no problem. Quite often the court says, look, High Court is hearing this, let the High Court decide, you can always come and appeal, etc. So, I mean, it's not cut and dried, it is not black and white. There are many grays in this.
Suppose it is dismissed on Monday.
But if it gets dismissed on Monday, then it kills the Bombay case also.
That's the point.
Yeah.
Okay.
Yeah. So the worry here was not of the judges, by the way. Judges have not said this.
Right.
The worry here of the people is that this is being taken up, will get dismissed, or a Bombay in which notice has already been issued, that will get killed. Exactly. This is what people's concern is, and that's what our party's concern is. Right. But the judge's concern is not what happens in the end, right, whether it's dismissed or not dismissed, etc. It should not be given in such a manner that it creates an impression that these are hand-picked benches that are getting these important matters, and why are the senior judges not getting these important matters? That is the concern of the judges, and I believe it's a legitimate concern.
You also agree that the Ayodhya case and the Aadhaar case were also mishandled by the CJI?
Well, the formulation that we have made, I think, covers. We haven't named these judgments, these cases, but our formulation covers, because we've said something that of great moment for nation and society. They should be heard by larger benches, and two, they should be heard by senior judges, etc. This is what we've said in our formulation, and I think that would cover these two.
I mean, is there any defense by the Chief Justice? Can he defend him in his decision to send it to the junior judges?
I would like to hear it. I mean,
he's not obliged to give.
No, he says I am the master of the roster, which everyone agrees.
Correct.
Everyone agrees that he's the master of the roster, but people don't agree on how the master of the roster should behave. That is the disagreement. That's the disagreement. So, but this would be apparent only if he came and gave a press conference. But as I said, he probably was advised, don't give a press conference, because then this is them against you, etc. Then it becomes like a tit for tat. And it's best if you find a solution and then come before the country and saying we found a solution.
The Bar Council of India or the Supreme Court Bar Association can do it for him.
Bar Association can, but they've already, Bar Association today, at least the president has taken the position that these judges shouldn't have done this. I hope he can convince his association that what he said was right. There are many differences. I mean, there are a whole lot of differences.